Do the respondents wish to make use of any reply?
Yes, please, so it's on the record.
Members of the tribunal, I will be very brief. I have assured Mr. Smith I will give him the bulk of the time. I would just like to make a couple of points on denial of benefits. Mr. Ali used the phrase, albeit in a different context, state responsibility on the international plane. And I think that that phrase is quite applicable to the denial of benefits issue before this tribunal. I apologize for this, but unfortunately, by invoking this concept, we have put a heavy burden upon this tribunal because it is the first tribunal, to my knowledge, to decide this denial of benefits issue in the context either of CAFTA or NAFTA. But the reason I raised the issue, or the phrase that Mr. Ali put on the screen a few moments ago, is because of something I heard in closing on denial of benefits today about how Mr. Shrake lives in Nevada and how he does everything in Nevada and how he is a U.S. citizen. I submit to this tribunal that something as profound as the issue of denial of benefits and whether or not the claimant has substantial business activities in the United States or controls someone from the United States cannot turn on the physical location of the chief executive officer of a company. It cannot turn on that issue, or even the citizenship of the chief executive officer of a company. There are many large international corporations today all over the world that are in many jurisdictions, and in fact some of them were born, to use another phrase that's been thrown around here, were born in places other than the U.S. but now have a chief executive officer in the U.S. In fact, I think Novartis is one of them. I may be mistaken, but if so, I know there are others. Now, let's look at what the rule urged by claimant would do to international relations and to the rule of denial of benefits. If a company like Novartis has a chief executive officer in the U.S., does substantial business in the U.S., and sets up a Cayman Islands subsidiary that, let's say, invests in El Salvador, and then years after the events leading up to the dispute have taken place, decides to move that subsidiary to the United States, can they take the position, which is the position that they have taken here, that claimant has taken in this arbitration, that because the chief executive officer of the parent is in the United States and has been there a long time, and because Novartis as a company, as a family of companies, does substantial business in the U.S., then surely that sub qualifies as having substantial business in the U.S. That cannot be the test, and there is no support for that being the test. Now, the argument was also made that when he was in the U.S., he made all of these decisions, and therefore he exercised control. And so we have not shown, claimant says, that control was exercised from Canada. But again, the words of Mr. Shrake belie that argument. I asked him directly yesterday whether the companies that he circled on our exhibit were controlled by the Canadian parent. The question was, and does Pacific Rim Mining Corp., that's the Canadian parent, also control all of these companies you just circled? Yes. The second point, and my final point, is simply on this issue of notice. Again, I would just like to say a few things. First of all, the treaty language does not have any time limit on when denial of benefits have to be invoked. Second, as Professor Stern correctly recognized, diplomatic protection is different, an entirely different concept from state to state consultations. And the argument that engaging in state to state consultations would somehow amount to giving diplomatic protection is not supported by any authority. And finally, I would just like to remind the Tribunal of El Salvador's waiver of any rights to make that argument. There was some suggestion that we could not affect the rights of other ICSID parties, but I would just leave the tribunal with the question, what other ICSID parties would even have standing to complain about any state-to-state consultations that the United States engaged in with El Salvador? On that note, unless the tribunal has any questions, I will cede the podium to Mr. Smith. Thank you.
We'll hear Mr. Smith.
Thank you for your indulgence.
Thank you, Mr. President, members of the tribunal. Mr. Posner indicated that he was going to clear up the confusion about the measure or measures that are the basis of their claim. Just in their presentations this afternoon, they've defined the measure in 3 different ways. With reference to the, or maybe even more, with reference to the press reports about President Saka, Mr. de Gramont said that is when the dispute began to crystallize. Mr. Ali, talking about the measures that destroyed their investment, said that happened after the meeting in June 2008. And then Mr. Posner said the de facto mining ban is confirmation of a practice. That is the measure at issue. It is very, very hard, and when Mr. Posner was asked directly to define the date on which the measure that interfered with their investment took place, he had a very elaborate theory as to why he could not identify that date. But the reality is that their definition of the measure has been a moving target throughout this arbitration in order to fit the legal theory that allows their case to continue. Mr. Posner referred to not being very clear in the drafting of the notice of intent. There's nothing unclear about the drafting of the notice of intent. There's nothing unclear about the drafting of the notice of arbitration. It is very clear. And when lawyers draft a document that initiates and refers to an arbitration under CAFTA, where the word measure is a defined term and a term of art, and then they say that their claims arise because of a measure and that those measures destroyed their investment, I find it hard to believe that they did not understand that they were alleging that those measures are their claims under CAFTA, and that somehow later on they realized that they only have one measure. It just doesn't, it does not fit. In fact, the measures that they refer to in their notice of intent are quite clear, and the other issue is that we don't know, or I don't know, perhaps the tribunal knows, what exactly they allege about the 2008 press report about President Saka. Was it a measure? Did it start a ban on mining? Did it crystallize a dispute? Did it inform them about a measure that already existed? Every time that they mention the article about President Saka, they have not put it on the screen once in these entire 3 days. And the reason for that is because the language in it doesn't support the interpretation that they would like to give it. They didn't show it once. They've referred to it and they've said what it says multiple times, and every time they've said what it says, it isn't the language used in it. It is a paraphrase that twists the language in it. Now, Mr. de Gramont indicated that El Salvador has not made mention to the documents that they have cited to after March 11th, 2008. They cite a number of additional press releases. We cited press releases from 2006 and 2007, which they seem to give no importance to. But there's a legal reason why we believe those press articles, and it's not a reason of convenience. The issue for abusive process is, as they have stated, did the dispute arise prior to December 13th, 2007? And they have specifically stated that that's the issue. Now, they cannot escape that claimant's position was that the dispute was fully crystallized in March of 2008 because they threatened arbitration to Mr. Saka, to the president of the country, directly under CAFTA, based on that, or at least by April 14th. Therefore, for the question of abusive process, the issue is that everything that happened after that is irrelevant because both parties agree that there was a dispute on that date. And the question is, did it arise before that date? So everything they've cited, the Funes articles, the additional Saka articles, are irrelevant to the inquiry of abusive process. The question is, what was the state of facts on December 13th, 2007? Now, I wanted to just briefly say something about the testimony of Ms. Hashimoto, or about Ms. Hashimoto in Mr. Schrake's witness statement. I believe if you read paragraph 110 carefully, she did not come up with the idea of changing the nationality of Pakrim Cayman. She came up with the idea of saving money by abolishing the operations where the subsidiaries where they had no operations in Peru and Mexico, and thereby abolishing Pakrim Caribe. And then Mr. Shrake goes on to say that as a result of this, and so the decision, as Mr. Shrake has admitted multiple times in this proceeding, the decision to change the nationality was Mr. Shrake's, not Ms. Hashimoto's. Now, I wanted to also address something Mr. Ali said. He said that a dispute doesn't arise for the purpose of abusive process until there's a concrete invocation of the instrument of jurisdiction. That would be a fantastic definition for claimants, because Pakrim Cayman could not invoke the instrument of jurisdiction until after the change of nationality, because they needed to change the nationality in order to invoke jurisdiction. This can't be the standard for abusive process, or abusive process would never exist. And no tribunal has ever even come close to that sort of a definition. And just let me conclude for El Salvador that El Salvador has put forward 4 very substantial objections to jurisdiction. Each and every one is sufficient to dismiss some or all of this arbitration. The primary objection is abusive process. And I urge the tribunal with that in that regard, to very carefully read the claimant's notice of intent, the claimant's notice of arbitration, and the press reports from March 2008 and Mr. Schrake's letter with regard to those press reports, as well as the other facts that have put into the record by El Salvador regarding the dispute, regarding the application for the exploitation concession, how that dispute developed from 2004 to 2007. Very carefully look at the facts, not the twisting of facts by claimant's counsel, not their redefinition of the measures upon which they base their case. Carefully look at the facts and come to a factual determination as to on what date the interference with the investment took place, on what date the dispute was born, and I think the inevitable conclusion is that it was before December 13th, 2007, and because they manipulated the nationality of claimant to gain access to CAFTA, that means they have abused process, and this entire arbitration must be dismissed. Thank you very much.
Thank you very much. Mr. Ali, you have 12 seconds. If you want to say 5 of them, you can address us sitting down.
I believe, in fact, that we're 12 seconds over, so we will rest on our submissions, our pleadings, and make further comments in our post-hearing submissions. Thank you, Mr. Chairman.
Thank you both for your, thank you all for your closing oral submissions. We now let's just to tidy up the procedure, which will start obviously when we adjourn in a few moments. First of all, we'd like to announce our decision regarding the so-called FAM document. Subject to any further submissions from the respondent, we are now minded to admit the FAM document into evidence and to request the respondent, if it wishes to do so, to address the claimant's argument we've just heard in its post-hearing brief. We don't need to hear that now. Does the respondent wish to make any further submissions opposing this introduction of the FAM document?
No, respondent won't make any further submissions.
As regards the procedural timetable, it's now agreed, and this order is immediately effective, although we'll confirm it in writing, that the deadline for any written submissions by CAFTA non-disputing parties is the 20th of May 2011. The deadline for any written submissions by the designated amici, that is designated by the Tribunal's previous order, is also the 20th of May 2011. The 10th of June 2011 is the agreed date for the parties to exchange and to submit to the Tribunal through the ICTID Secretariat their post-hearing briefs. We're talking of one round. We discussed yesterday the desirability of agreeing or imposing a page limit, and we asked the parties whether they've discussed that between themselves. We have a figure in mind if they haven't. We asked the respondents first.
We haven't actually discussed a figure.
No, we'll be guided by the Tribunal.
50 pages. Will that cause any difficulties to either side?
Not to respondent.
We trust them. Yes, it has to be in legible print of a suitable font. And it includes all footnotes and endnotes, and we'd like spaces between the words. But we trust you. We'd like, with that, obviously, on one view of what happens with our decision, we may have to address costs, and that's the claims which is made by the respondent. So I think we need a brief summary as regards both allocation and quantification of costs that are being sought by both sides. We'd like that with your post-hearing submissions on the 10th of June. It needn't be very long. We're not asking for an audit, but enough to give the other side some idea of why and what is being claimed. And then we'd suggest that within a very short time limit, there ought to be a very brief response if you're minded to respond to those cost submissions. Yeah, I'm going to put that in. Now, do you have any date in mind? Can I ask the respondents first for doing any response on the cost submissions from the other party?
I have not looked at a specific date, but given other matters that do, I would ask that it be after the 17th of June.
Well, if we said 2 weeks, would that be convenient to the
That's
claimants
fine
too?
for us, Mr. Chairman.
So we'll do 2 weeks. Now, apart from anything relating to costs, we close the file at this stage as regards our decision. There's to be no new evidence of any kind submitted to us. That's understood, I hope, by the respondents and the claimants.
Confirmed by claimants, Mr. Chairman.
Can I say...
Sorry, Mr. Chairman, with one proviso, which is the application that was made by Mr. Posner in his presentation for the information that Mr. Parada claims is being investigated and that will be provided.
As I understood that application, it was made to the tribunal, and obviously the tribunal can order a party to introduce new material, but we haven't made an order in respect of that application. We're not wanting the parties to volunteer in the post-hearing brief further evidence, or indeed at any other stage after today, except for costs, and I think we ought to add maybe except if there's any response to the FAM document. If that causes any difficulties to either side, we need to hear that now and resolve it. Is there any difficulty on the respondent side with that approach?
No difficulty.
And on the claimants?
No difficulty.
The transcript, as always, is perfect, and I'm not going to insinuate otherwise, but if there's any correction to the transcripts, particularly to the testimony, we're not talking about obvious mistakes, we'd like that to be notified within the next 7 days. Is that agreeable to both sides? We ask the respondents first.
Yes.
Is there anything else we need to address at this stage? We ask the respondents first. On laisse ça. On laisse. On peut les écrire. Ils ont un peu, on va discuter demain.
Nothing further from respondent.
Mr. Chairman, you had mentioned an issue that you didn't want to forget that we addressed, but I can't remember what it is. Yeah, so perhaps it is forgotten, but the other thing is that you had yesterday said, yes, yesterday you'd also indicated that there may be more questions forthcoming from the tribunal. If we could set a date by which we might get those.
Can I suggest that, in fact, we'll raise those after we've read your post-hearing briefs? You're pretty good at answering a lot of questions that we have in mind, and even questions we haven't thought of. So we'll anticipate first reading your post-hearing briefs, but then we may have further questions, fairly specific questions. But I suspect if we ask them now, these are probably something you already have well in mind, or indeed have previously answered already in some of your extensive written material. So we'll leave that for the moment. But please be assured, if we have any further questions, we won't hesitate to ask you both to address them.
Mr. President, I think perhaps the issue that Mr. Ali was referring to was the provision of transcripts to the...
Of course. Let's come back to that. First of all, there's no difficulty in our supplying copies of transcripts to the non-disputing CAFTA parties, I take it. From either side, we can do that.
No problem from respondent.
And from the claimants?
None from claimant. I've just confirmed that with Mr. Trigg.
Now, we understood that fairly swiftly after we indicated there was a problem, the live feed resumed. So we assumed that it may be only about 15, 20 minutes was missing at the most. So I suspect people who had access to what's been happening here, including the amici, but it may be that they would wish to have a transcript of the 3 days. Is there any difficulty about providing that transcript either by the parties, the disputing parties, or by the exit secretariat? We ask the respondents first.
No difficulty for respondent.
And the claimants?
None from us, Mr. Chairman, although we would prefer it be provided by the exit secretariat.
Okay. Well, then we'll do that. Okay. Now, the usual question at this stage, as you appreciate, sometimes members of arbitration tribunals, especially exit tribunals, are only human beings and they can make mistakes. Is there anything either of you wish to raise here by way of a procedural mishap that we need to correct if we can do so at this stage. It's a fairly formal question, but we ask the respondents formally first.
Nothing from respondent.
And from the claimants?
Nothing with respect to this particular phase, Mr. Chairman.
Thank you very much. Well, Deering, I think, allows me to say on behalf of the tribunal, and I'm sure the parties too, a big thank you to our shorthand writers, without whom this would be a memory feat of distinction, and to thank also the interpreters whom we haven't seen but have been laboring in the back, and also the technicians behind us who've been providing the live feed. And we don't know how many people. They may have reduced significantly over the last 3 days, but they may still be quite numerous. And I think from the tribunal side, we'd like to express our great thanks to all the counsel and the support staff. It's been a very interesting and a very efficient hearing in what is not an easy case, perhaps for any of us. So thank you all very much, and I formally close this hearing.
Thank you.